On Law Weekly today, we stick with the very contentious Electoral Act Amendment Bill. My guest is a senior legal practitioner, Dr. Khrushchev. We also have the views of some lawyers on the failure of the executive to appoint a substantive chief judge of the Federal High Court, plus our recap of the top trending stories in the news. That's the lineup on this episode of the program. I'm Shola Shoyeli. We're sticking with the very contentious issue of the sequence of elections, which has continued to generate so much attention. Last week, we brought you the opinions of a senior advocate of Nigeria, Robert Clark. And this week, we serve you another view. My guest, Dr. Ekweme, is a partner in the law firm of Olaniwo Ajayi and a visiting researcher at the Harvard Law School. He specializes in international economic law, dispute resolution, and much more. I began the interview by asking his interpretation of the relevant powers of INEC on the issue of sequence of elections.
The issue is, does the National Assembly have the power to reorder the sequence of the 2019 election, having regard to the powers of the INEC under the 1999 Constitution as amended? Now, the relevant powers of the INEC in relation to elections will be found in Section 15A of the third schedule to the 1999 Constitution as amended, and also in Sections 132 of the Constitution, Section 76 of the Constitution, Section 116 of the Constitution, and Section 178 of the Constitution. And Section 132 of the Constitution gives the INEC the power to fix the date for the election of the president in accordance with the provisions of the Electoral Act. Now, the question is, and which is the heart of the debate, is can INEC fix elections without looking at the provisions of the Electoral Act? Or must the Electoral Act control the decision of the INEC in relation to the date for federal and state elections? The Constitution has given the INEC the express power to fix the date for federal and state elections. Now, I am acutely conscious of the fact that the Constitution says that the INEC shall fix those dates in accordance with the Electoral Act. And that brings the ambiguity that I articulated initially, whether the Constitution says, or that under the Constitution, the INEC must look at the Electoral Act, in which case the National Assembly can amend the Electoral Act and the INEC will be bound by the Electoral Act in relation to the sequence of the election. Or the Constitution has given INEC the power to fix the date without reference to the Electoral Act. And in my position is that in order to deal with this ambiguity, the Supreme Court has given guidance on interpretation of our Constitution. According to the Supreme Court, in the case of Saraki and the FRN, the Supreme Court restated what the court has said in numerous cases, that in interpreting the Constitution, the court should not be slavish to the literal meaning of the words used in the Constitution, but to discover the object and purpose of the Constitution and effectuate that object and purpose of the Constitution. I believe that the framers of the Constitution applied their minds to this provision, to this problem that we are facing today, and specified that the INEC shall have the power to fix those dates. Because the intendment will be to insulate the dates from political interference. And that is why they gave INEC the independent National Electoral Commission, an independent body, that power to fix those dates. Because the fixing of those dates can be used by either the executive branch of government or the legislative branch of government to suit their purposes. And under our system, the Constitution is the highest in our hierarchy of laws. And by Section 1, Sub 3 of the Constitution, any law that is inconsistent with the provision of Constitution shall be null and void. So even if the National Assembly goes ahead, to override the decision of the president to withhold assent to the bill to the principal electoral act and eventually enacts I think the provision of the new Section 25 of the Electoral Act to reorder the sequence of that election. I believe that the INEC can still go ahead and disregard that reordering because the Constitution expressly gives INEC the power to fix the date.
It appears like there's a conflict in the laws. How do you think that we can cure that?
Well, what I think is that the law can be amended, to clarify the law, clarification, and not amended as to change what does not exist today. Because what exists today is that the power resides in INEC, albeit in an ambiguous way. So the amendment that I propose is an amendment that will clarify the law. There's a provision of the Constitution that created problems in relation to the elongation of the tenure of the governor, I think in the case of Marwa and INEC, a constitutional amendment was subsequently made to clarify the law, but not to really change the intent and purpose of the law. So there has to be a